Given this administration's open and active contempt for the United States Constitution, I felt this was an excellent opportunity to discuss the actual contents of the United States Constitution. This may not be the most fascinating subject matter, but it is at this time and place in history some of the most crucially important, as we witness the occupants of some of our most powerful political positions violated daily. I was introduced to the nuances of this foundational document during my sophomore year of high school by Mr. Robert Ayton, who reminded us every single day of that semester that you cannot protect your rights if you don't know your rights, that the unalienable rights of the people are inherent to every one of us by virtue of our existence as living human beings, and that a constitution is a document by which the people outline and define what authorities they allow the government they create to exercise. Now, I've come to accept that the fine art of performing a Boolean keyword search seems all but lost, and the ability to differentiate between fact, fiction, fallacy, and falsity is an uncommon virtue. But you are seeing this now, so this is where you are, and because that's the case, I am going to bring the information here to you in order to meet you where you are. Today I commit an act most revolutionary, a recitation of the United States Constitution beginning with the preamble, a comprehensive 52-word sentence that sets the scene for the most important legal document in the history of this nation. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution of the United States of America. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. These 25 words comprise Section 1 of Article 1 of the United States Constitution and establish that Congress, and only Congress, is legally authorized to perform the various tasks and functions that will be outlined specifically in Article 1 of the Constitution, and further that Congress may not delegate any of these legislative powers, tasks, or functions to any other branch of the federal government. This makes it one of 3 sections throughout the Constitution known as vesting clauses, and it, along with the first section of Article 2 and the first section of Article 3, explicitly forms the foundation for the separation of powers and the system of checks and balances that separation creates among the 3 branches of the United States federal government that are crafted and defined in the first 3 articles of the Constitution. This first section of Article 1 also establishes what's known as a bicameral legislature, or a governmental body made up of 2 distinct parts referred to as chambers. In this case, a Senate, which will be defined in Section 3 of this first article, and a House of Representatives, which will be defined in Section 2. Section 2 of Article 1 of the United States Constitution indicates that the House of Representatives shall be composed of members chosen every second year by the people of the several states, and the electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature. No person shall be a representative who shall not have attained to the age of 25 years and been 7 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state in which he shall be chosen. Representatives and direct taxes shall be apportioned among the several states which may be included within this union, according to their respective numbers, which shall be determined by adding to the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed, 3/5 of all other persons. The actual enumeration shall be made within 3 years after the first meeting of the Congress of the United States, and within every subsequent term of 10 years, in such manner as they shall by law direct. The number of representatives shall not exceed 1 for every 30,000, but each state shall have at least 1 representative. And until such enumeration shall be made, the state of New Hampshire shall be entitled to choose 3, Massachusetts 8, Rhode Island and Providence Plantations 1, Connecticut 5, New York 6, New Jersey 4, Pennsylvania 8, Delaware 1, Maryland 6, Virginia 10, North Carolina 5, South Carolina 5, and Georgia 3. When vacancies happen in the representation from any state, the executive authority thereof shall issue writs of election to fill such vacancies. The House of Representatives shall choose their Speaker and other officers, and shall have the sole power of impeachment. Section 3 of Article 1 of the United States Constitution indicates that the Senate of the United States shall be composed of 2 senators from each state, chosen by the legislature thereof for 6 years, and each senator shall have 1 vote. Immediately after they shall be assembled in consequence of the first election, they shall be divided as equally as may be into 3 classes. The seats of the senators of the first class shall be vacated at the expiration of the second year, of the second class at the expiration of the 4th year, and of the third class at the expiration of the 6th year, so that 1/3 may be chosen every second year. And if vacancies happen by resignation or otherwise during the recess of the legislature of any state, the executive thereof may make temporary appointments until the next meeting of the legislature, which shall then fill such vacancies. No person shall be a senator who shall not have attained to the age of 30 years and been 9 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state for which he shall be chosen. The Vice President of the United States shall be the President of the Senate, but shall have no vote unless they be equally divided. The Senate shall choose their other officers, and also a President pro tempore, in the absence of the Vice President, or when he shall exercise the office of President of the United States. The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present. Judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States, but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. Section 4 of Article 1 of the United States Constitution indicates that the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations except as to the places of choosing senators. The Congress shall assemble at least once in every year, and such meeting shall be on the first Monday in December unless they shall by law appoint a different day. Congress did eventually appoint a different day in January of 1933 with the ratification of the 20th Amendment, Section 2 of which reads, "The Congress shall assemble at least once in every year, and such meeting shall begin at noon on the 3rd day of January, unless they shall by law appoint a different day," aligning that congressional meeting with the end of the terms of senators and representatives set in that amendment's first section. This fourth section of the Constitution's first article also serves as the foundation for several subsequent amendments, including the 15th, the 19th, the 24th, and the 26th, by which Congress altered the manner of holding elections for senators and representatives by prohibiting discrimination on account of race, color, or previous condition of servitude, sex, failure to pay any poll tax or other tax, or age for citizens who are 18 years of age or older, respectively. Section 5 of Article 1 of the United States Constitution indicates that each House shall be the judge of the elections, returns, and qualifications of its own members, and a majority of each shall constitute a quorum to do business. But a smaller number may adjourn from day to day, and may be authorized to compel the attendance of absent members, in such manner and under such penalties as each House may provide. Each House may determine the rules of its proceedings, punish its members for disorderly behavior, and with the concurrence of 2/3 expel a member. Each House shall keep a journal of its proceedings, and from time to time publish the same, excepting such parts as may in their judgment require secrecy. And the yeas and nays of the members of either House on any question shall, at the desire of 1/5 of those present, be entered on the journal. Neither House during the session of Congress shall, without the consent of the other, adjourn for more than 3 days, nor to any other place than that in which the two Houses shall be sitting. 21 congressmen have been expelled in American history, 17 of whom were Democrats expelled for supporting the Confederacy during the war between the states. The most recent expulsion was that of New York Republican George Santos in 2023, before which Ohio Democrat James Traficant Jr. was expelled in 2002, and Pennsylvania Democrat Michael Myers was expelled in 1980, though not for being the villain in a series of slasher films. Section 6 of Article 1 of the United States Constitution indicates that the senators and representatives shall receive a compensation for their services to be ascertained by law and paid out of the Treasury of the United States. They shall in all cases except treason, felony, and breach of the peace be privileged from arrest during their attendance at the session of their respective houses and in going to and returning from the same. And for any speech or debate in either house, they shall not be questioned in any other place. No senator or representative shall, during the time for which he was elected, be appointed to any civil office under the authority of the United States, which shall have been created, or the emoluments whereof shall have been increased during such time. And no person holding any office under the United States shall be a member of either house during his continuance in office. This section authorizes Congress to determine its own salaries and pay themselves from the federal treasury, abandoning a practice established by the Articles of Confederation under which senators and representatives were paid by the states they represented. This provision of Section 6 was later amended in May of 1992, more than 200 years later, with the ratification of the 27th Amendment, which states that no law varying the compensation for the services of the senators and representatives shall take effect until an election of representatives shall have intervened. Section 7 of Article 1 of the United States Constitution indicates that all bills for raising revenue shall originate in the House of Representatives, but the Senate may propose or concur with amendments as on other bills. Every bill which shall have passed the House of Representatives and the Senate shall, before it become a law, be presented to the President of the United States. If he approve, he shall sign it, but if not, he shall return it with his objections to that House in which it shall have originated, who shall enter the objections at large on their journal and proceed to reconsider it. If after such reconsideration 2/3 of that House shall agree to pass the bill, it shall be sent, together with the objections, to the other House, by which it shall be likewise reconsidered, and if approved by 2/3 of that House, it shall become a law. But in all such cases, the votes of both houses shall be determined by yeas and nays, and the names of the persons voting for and against the bill shall be entered on the journal of each House respectively. If any bill shall not be returned by the President within 10 days, Sundays excepted, after it shall have been presented to him, the same shall be a law, in like manner as if he had signed it, unless the Congress by their adjournment prevent its returns, in which case it shall not be a law. Every order, resolution, or vote to which the concurrence of the Senate and House of Representatives may be necessary, except on a question of adjournment, shall be presented to the President of the United States, and before the same shall take effect, shall be approved by him, or being disapproved by him, shall be repassed by 2/3 of the Senate and House of Representatives, according to the rules and limitations prescribed in the case of a bill. Section 8 of Article 1 of the United States Constitution indicates that the Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States. To borrow money on the credit of the United States. To regulate commerce with foreign nations and among the several states and with the Indian tribes. To establish an uniform rule of naturalization and uniform laws on the subject of bankruptcies throughout the United States. To coin money, regulate the value thereof and of foreign coin, and fix the standard of weights and measures. To provide for the punishment of counterfeiting the securities and current coin of the United States. To establish post offices and post roads. To promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. To constitute tribunals inferior to the Supreme Court. To define and punish piracies and felonies committed on the high seas and offenses against the law of nations. To declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water. To raise and support armies, but no appropriation of money to that use shall be for a longer term than 2 years. To provide and maintain a navy. To make rules for the government and regulation of the land and naval forces. To provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. To provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively the appointment of the officers and the authority of training the militia according to the discipline prescribed by Congress. To exercise exclusive legislation in all cases whatsoever over such district, not exceeding 10 miles square, as may, by cession of particular states and the acceptance of Congress, become the seat of the government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. And to make all laws which shall be necessary and proper for carrying into execution the foregoing powers of all powers vested by this Constitution in the government of the United States or in any department or officer thereof. Section 9 of Article 1 of the United States Constitution indicates that the migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1808, but a tax or duty may be imposed on such importation not exceeding $10 for each person. The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion the public safety may require it. No bill of attainder or ex post facto law shall be passed. No capitation or other direct tax shall be laid unless in proportion to the census or enumeration herein before directed to be taken. No tax or duty shall be laid on articles exported from any state. No preference shall be given by any regulation of commerce or revenue to the ports of one state over those of another. Nor shall vessels bound to or from one state be obliged to enter, clear, or pay duties in another. No money shall be drawn from the Treasury but in consequence of appropriations made by law. And a regular statement and account of the receipts and expenditures of all public money shall be published from time to time. No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of Congress, accept any present, emolument, office, or title of any kind whatever from any king, prince, or foreign state. Section 10 of Article 1 of the United States Constitution indicates that no state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. No state shall, without the consent of the Congress, lay any imposts or duties on imports or exports, except what may be absolutely necessary for executing its inspection laws. And the net produce of all duties and imposts laid by any state on imports or exports shall be for the use of the Treasury of the United States. And all such laws shall be subject to the revision and control of the Congress. No state shall, without the consent of Congress, lay any duty on tonnage, keep troops or ships of war in time of peace, enter into any agreement or compact with another state or with a foreign power, or engage in war unless actually invaded or in such imminent danger as will not admit of delay. Clauses 1 through 4 of Section 1 of Article 2 of the United States Constitution indicate that the executive power shall be vested in a President of the United States of America. He shall hold his office during the term of 4 years, and together with the Vice President, chosen for the same term, be elected as follows. Each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress. But no senator or representative or person holding an office of trust or profit under the United States shall be appointed an elector. The electors shall meet in their respective states and vote by ballot for 2 persons, of whom one at least shall not be an inhabitant of the same state with themselves. And they shall make a list of all the persons voted for and of the number of votes for each, which list they shall sign and certify and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the vote shall then be counted. The person having the greatest number of votes shall be the President, if such number be a majority of the whole number of electors appointed. And if there be more than one who have such majority and have an equal number of votes, then the House of Representatives shall immediately choose by ballot one of them for President. And if no person have a majority, then from the 5 highest on the list, the said House shall in like manner choose the President. But in choosing the President, the vote shall be taken by states, the representation from each state having 1 vote. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. In every case, after the choice of the President, the person having the greatest number of votes of the electors shall be the Vice President. But if there should remain 2 or more who have equal votes, the Senate shall choose from them by ballot the Vice President. The Congress may determine the time of choosing the electors and the day on which they shall give their votes, which day shall be the same throughout the United States. Clauses 5 through 8 of Section 1 of Article 2 of the United States Constitution indicate that no person except a natural-born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of President. Neither shall any person be eligible to that office who shall not have attained to the age of 35 years and been 14 years a resident within the United States. In case of the removal of the President from office, or of his death, resignation, or inability to discharge the powers and duties of the said office, the same shall devolve on the Vice President, and the Congress may by law provide for the case of removal, death, resignation, or inability, both of the President and Vice President, declaring what officer shall then act as President, and such officer shall act accordingly until the disability be removed or a President be elected. The President shall at stated times receive for his services a compensation, which shall neither be increased nor diminished during the period for which he shall have been elected, and he shall not receive within that period any other emolument from the United States or any of them. Before he enter on the execution of his office, he shall take the following oath or affirmation. I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. Section 2 of Article 2 of the United States Constitution indicates that the President shall be Commander-in-Chief of the Army and Navy of the United States and of the militia of the several states when called into the actual service of the United States. He may require the opinion in writing of the principal officer in each of the executive departments upon any subject relating to the duties of their respective offices, and he shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. He shall have power by and with the advice and consent of the Senate to make treaties, provided 2/3 of the senators present concur, and he shall nominate and by and with the advice and consent of the Senate shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of departments. The President shall have power to fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of their next session. Section 3 of Article 2 of the United States Constitution indicates that the President of the United States shall from time to time give to the Congress information of the state of the Union and recommend to their consideration such measures as he shall judge necessary and expedient. He may on extraordinary occasions convene both houses or either of them, and in case of disagreement between them with respect to the time of adjournment, he may adjourn them to such time as he shall think proper. He shall receive ambassadors and other public ministers. He shall take care that the laws be faithfully executed, and shall commission all the officers of the United States. This section establishes the presidential practice of delivering what is now the annual address known as the State of the Union, though it does not specifically require that the president give such information either verbally or in person. For that reason, Thomas Jefferson, in the interest of ensuring the separation of powers created by this Constitution, instituted the practice of writing his addresses and transmitting them to Congress where they were read by a clerk, a practice that continued until Woodrow Wilson began delivering his yearly speeches before Congress in person during World War I. Section 4 of Article 2 of the United States Constitution indicates that the President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. 3 American presidents have been successfully impeached a total of 4 times in the last 236 years, though none of them have been convicted and removed from office by the Senate. Andrew Johnson was impeached in 1868 on 3 articles involving the violation of the Tenure of Office Act, and while he received 35 guilty votes and just 19 not guilty votes, the 3rd section of the first article requires the concurrence of 2/3 of the members present to convict, meaning that Johnson was acquitted by a single vote. Bill Clinton was impeached in 1998 on 2 articles of perjury and obstruction of justice, and was acquitted by votes of 45 to 55 and 50 to 50 respectively. Donald Trump was impeached in 2019 on 2 articles of abuse of power and obstruction of Congress, and was acquitted by votes of 48 to 52 and 47 to 53 respectively. And Trump was again impeached a second time in 2021 on a single article of incitement of insurrection, receiving 57 guilty votes and just 43 not guilty votes. Only 2 cabinet members have ever been impeached: Secretary of War William Belknap in 1876 and Secretary of Homeland Security Alejandro Mayorkas in 2024, both of whom were acquitted at trial. Associate Justice Samuel Chase was impeached in 1804, becoming the first Supreme Court justice to be successfully impeached, and was acquitted of all 8 articles. 14 other judges have been impeached, 8 of whom were successfully removed from office, the most recent being Clinton appointee Thomas Porteous in 2010. Section 1 of Article 3 of the United States Constitution indicates that the judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, and shall at stated times receive for their services a compensation, which shall not be diminished during their continuance in office. This makes it one of 3 sections throughout the Constitution known as vesting clauses, and it, along with the first section of Article 1 and the first section of Article 2, explicitly forms the foundation for the separation of powers and the system of checks and balances that separation creates among the 3 branches of the United States federal government that are crafted and defined in the first 3 articles of the Constitution. Congress created the first inferior courts in 1789 by dividing the United States into 13 districts, each with its own district court, and then further dividing 11 of those 13 districts into 3 circuits, each with its own circuit court. This first section does not specify the number of seats that the Supreme Court is meant to include, though the 3rd section of Article 1 mentions a Chief Justice who shall preside over any Senate impeachment trials of American presidents. Congress initially established in 1789 that the Supreme Court of the United States shall consist of a Chief Justice and 5 Associate Justices, and briefly reduced that number to 5 justices only in 1801 before restoring it to 6 in 1802, after which it increased to 7 in 1807, 9 in 1837, and 10 in 1863. That number dwindled to 9 in 1866 and 8 in 1867, after which Congress returned the number to 9, a Chief Justice and 8 Associate Justices, making it one of the smallest Supreme Courts in the world. Section 2 of Article 3 of the United States Constitution indicates that the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority. To all cases affecting ambassadors, other public ministers, and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof and foreign states, citizens or subjects. In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. The trial of all crimes, except in the cases of impeachment, shall be by jury, and such trial shall be held in the state where the said crime shall have been committed. But when not committed within any state, the trial shall be held at such place or places as the Congress may by law have directed. Section 3 of Article 3 of the United States Constitution indicates that treason against the United States shall consist only in levying war against them, or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act, or on confession in open court. The Congress shall have power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. This is the third and final mention of attainder in the Constitution, after sections 9 and 10 of Article 1, all instances of which prohibit its implementation. Attainder is a specific form of punishment under English law in which, in addition to being executed, a person convicted of certain capital crimes, including treason, was first stripped of their property and any hereditary titles which were seized by the government in such a way that the offender's heirs could no longer legally inherit them. The inability of heirs to inherit property or titles from an attainted individual, then, was a condition known as corruption of blood, as it was intended to punish not only the offender, but the offender's entire family and bloodline. Congress subsequently passed the Crimes Act of 1790, Section 24 of which further clarified that no conviction or judgment for any of the offenses listed in the Act shall work corruption of blood or any forfeiture of estate. Section 1 of Article 4 of the United States Constitution indicates that full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. And the Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be proved and the effect thereof. This was recently the foundation of the Respect for Marriage Act, which was passed in 2022 and which repealed the so-called Defense of Marriage Act, which itself had been passed in 1996 and had amended the United States Code to define marriage as an arrangement between one man and one woman, explicitly permitting states to refuse to recognize certain marriages legally conducted in other states in violation of the Full Faith and Credit Clause. Representative Tammy Baldwin, the author of the Respect for Marriage Act, indicated that bill's authority emerges from the provisions of the 4th Article's first section, specifically amending Section 1738C of Title 28 of the United States Code to read, "No person acting under color of state law may deny full faith and credit to any public act, record, or judicial proceeding of any other state pertaining to a marriage between two individuals on the basis of the sex, race, ethnicity, or national origin of those individuals." The mention of race here specifically refers to the fact that interracial marriage was once illegal in several states, an injustice corrected in 1967 with Loving v. Virginia, a landmark Supreme Court case that laid the groundwork for the 2015 case Obergefell v. Hodges, and which is now celebrated every June 12th on Loving Day. Section 2 of Article 4 of the United States Constitution indicates that the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. A person charged in any state with treason, felony, or other crime, who shall flee from justice and be found in another state, shall, on demand of the executive authority of the state from which he fled, be delivered up to be removed to the state having jurisdiction of the crime. No person held to service or labor in one state under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due. This section provides for the extradition of anyone charged in one state with any crime from any other state, whether they fled after they were charged or not. This section also includes what is commonly known as the Fugitive Slave Clause, submitted by South Carolinians Pierce Butler and Charles Pinckney against the objections of Philadelphian and future Supreme Court Justice James Wilson. The text goes out of its way to avoid mentioning slavery by name, referring to slaves as persons held in service or labor, and to slaveholders as parties to whom such service or labor may be due. The section was later reinforced by the Fugitive Slave Act of 1793 and the Fugitive Slave Act of 1850, both of which violated the right of abolitionist states to provide sanctuary to and protect the life and liberty of the people within their borders, though the clause was eventually upended in December of 1865 by the ratification of the 13th Amendment, which states in part that neither slavery nor involuntary servitude shall exist within the United States except as a punishment for crime. Section 3 of Article 4 of the United States Constitution indicates that new states may be admitted by the Congress into this union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of two or more states or parts of states without the consent of the legislatures of the states concerned as well as of the Congress. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. And nothing in this Constitution shall be construed as to prejudice any claims of the United States or of any particular state. The first new state was admitted to the Union under this provision on March 4th of 1791. The state of Vermont was formed from the Vermont Republic, though that territory had, prior to the siege of Yorktown in 1781, been negotiating with Britain to become part of the province of Quebec. The most recent addition to the Union was the state of Hawaii, formed from the territory of Hawaii, and admitted on August 21st of 1959, just 7.5 months after the state of Alaska had been admitted as the 49th state on January 3rd of that year. Current efforts to admit a 51st state to the Union include a statehood movement in Puerto Rico, whose residents have been granted United States citizenship since 1917, and the State of Washington, D.C. Admission Act, which seeks to convert the District of Columbia into a state that would become known as Douglas Commonwealth after Frederick Douglass. Section 4 of Article 4 of the United States Constitution indicates that the United States shall guarantee to every state in this union a republican form of government, and shall protect each of them against invasion, and on application of the legislature or of the executive when the legislature cannot be convened against domestic violence. The term republican comes from the Latin word res, meaning thing, and publicus, meaning belonging to the people, making a republican form of government one that belongs to and is controlled by the people, deriving its just powers from the consent of the governed, as Thomas Jefferson and the Committee of Five wrote in the Declaration of Independence, by way of democratically elected representatives. The republican form of government in the United States is a representative democracy, a term that comes from the Greek word demos, meaning the people, and kratia, meaning strength or power, in which the wishes of the people are, hypothetically, enacted by the people elected by popular vote to represent them. The American political party that would appropriate the term into its name would be formed in 1854, just 7 years before the first Republican president waged the war between the states against the Confederacy. Article 5 of the United States Constitution indicates that the Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures of 2/3 of the several states shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution, when ratified by the legislatures of 3/4 of the several states, or by conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress, provided that no amendment which may be made prior to the year 1808 shall in any manner affect the first and fourth clauses in the 9th section of the first article, and that no state without its consent shall be deprived of its equal suffrage in the Senate. This provision requires the approval of 75% of the states in the Union to ratify any constitutional amendment, and it outlines the two methods by which potential amendments can be proposed. The first is by a vote of at least 67% of the Senate and 67% of the House, and this is the method by which all 27 amendments to the Constitution have been proposed. The second is by a submission of applications by 67% of the states in the Union on a particular matter, which would require Congress to hold a convention at which representatives of the state legislatures could propose and discuss potential amendments, which has never been successfully accomplished. The closest that any proposal has come to achieving this Article 5 Convention of States has been a measure requiring the federal government to annually approve a balanced budget. Outstanding applications from 28 states have proposed the amendment, 5 short of the 33 states required to compel Congress to call a convention, with the most recent having been submitted by the state of Florida in February of 2024, and 16 of the 28 having been submitted in just the last 15 years. The next most commonly proposed measure is one imposing term limits on members of Congress. Outstanding applications from 11 states have proposed the amendment, with the most recent having been submitted by the state of North Carolina in December of 2024, and 10 of the 11 applications having been submitted in just the last 9 years. Article 6 of the United States Constitution indicates that all debts contracted and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. And the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. But no religious test shall ever be required as a qualification to any office or public trust under the United States. This article includes what is known as the Supremacy Clause, under which any state or federal law that contradicts the stipulations of this Constitution can be struck down as unconstitutional. The article also forbids religious requirements for holding any office in the United States. A prohibition that the Supreme Court ruled unanimously in 1961 protects the rights of non-believers to hold public office. Despite that ruling, the constitutions of 7 states in the Union, those being Maryland, Arkansas, Mississippi, North Carolina, South Carolina, Tennessee, and Texas, still explicitly ban non-believers from holding office, making those sections of those state constitutions unconstitutional. Article 7 of the United States Constitution indicates that the ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution between the states so ratifying the same. These 24 words thus conclude the second of the 3 documents known as the Charters of Freedom, the first being the Declaration of Independence, and the third being the collection of amendments known as the Bill of Rights. Though this 7th article does not require a unanimous agreement, over the course of the next 3 years, all 13 states did ultimately vote to ratify the document and implement the Constitution. Delaware was the first in December of 1787 with its own unanimous vote of 30-0, followed by Pennsylvania with a vote of 46-23, and New Jersey with another unanimous vote of 38-0. Georgia followed in January of 1788 with its own unanimous vote of 26-0, after which Connecticut, Massachusetts, Maryland, and South Carolina ratified the document throughout the first half of 1788. On June 21st of that year, New Hampshire became the 9th state to approve the Constitution by a vote of 57-47, establishing it as the supreme law of the land, after which Virginia and New York followed suit over the next 5 weeks. North Carolina subsequently approved the Constitution by a vote of 194-77 in November of 1789, after which Rhode Island ratified the document in May of 1790 by the narrowest margin of any state with a vote of 34-32.